I'm Marlena McWilliams, the principal owner and team lead of Mascotti and Company. Mascotti and Company is a local real estate firm here in the Washington metro area. We service buyers, sellers, investors, landlords, and tenants all throughout DC, Maryland, and Virginia. However, today I'm not here to talk about my company, myself, or our buyers or sellers. I'm here to talk about the $418 million settlement coming out of the state of Missouri against the National Association of Realtors, formerly known as NAR. Many people have been asking me, what does that mean for them today? And I'm here to give you all the facts of what the NAR settlement means. Number one, really, if you're a true practitioner of the practice, it means no change for you. Most of us in about 18 to 22 states formally have a buyer agency agreement, whereby as a buyer signs an agreement with a professional realtor to agree that the realtor would work with them, advise them, and have a fiduciary duty to help them get the best deal that they could in finding their next home, investment, place of business, or a place to live. However, there are still states that do not have a formal buyer agency agreement. So let's take a moment and dive into the history of where buyer agency agreement even came from in the first place. So prior to the early 1990s, buyer agency agreement did not exist. I mean, can you imagine today going in a home and you only got to talk to a sales representative that's there specifically to represent the seller and the seller's interests? That's like going to court and not having your own attorney, or going to have surgery and not having a surgeon that has practiced on countless cadavers before they practice on you. You always want to have somebody representing you, your interests, or being a specific leader or practitioner of a practice when it comes to health, wealth, and of course, divorce and death. So, buyer agency, there's two forms. There's a exclusive and non-exclusive. Non-exclusive means you have the right to use multiple realtors at once. But then it's kind of like game theory. You're moving around, you're forgetting which one sent you a home. And truthfully, are they all going to work as hard as they should for you? Because they feel no connection or onuses that you are going to represent them and be a partner in the agreement with them. The most common form is exclusive, and most of the agreements allow for cancellation. However, some states are unilateral, which means just one side can cancel, or it's mutual, which means both sides have to agree. But if you are a real realtor, that means you don't want business that's not good for you, and you wouldn't want to represent a client that did not feel comfortable with you representing them and the services that you provided. So most realtors, of course, would not keep business that's not good and beneficial for the client and themselves. Going back even further to the early 1990s, the court case where buyer agency began happened in Missouri. There was an agency which was representing a seller and representing a buyer, which we call dual agency today, and I'll go over that. In that court case, they sued because they felt that the agent who was acting as a dual agent represented the seller more than their own interests. So let's talk about what's going on in the Wild Wild West. The Midwest states are causing all these class action suits. In the 1990s, it was to have buyer agency. Now, Minnesota is coming back in the 2000s and saying, we want to almost get rid of buyer agency. That is insane. I'm from the Midwest. I'm from Colorado. I think we need to get our act together, Wild Wild West. We need to keep laws in place that protect us all and consumers in many different facets. So, as I stated, buyer agency didn't start to the 1990s. It used to be a buyer's beware market, which meant you knew you were going and looking at a house and you had no representation. Then after that court case, 22 states today now enacted laws of actual buyer agency, which means that the realtor and their onuses and their care, concern, and clarity and fiduciary duty is to you, the buyer. You always want to have that in place, and you want to understand what that realtor's services entail. Now, coming to today, what does it really mean with this new court case? For the Washington metro area where I serve, it's business as usual. We have always had a buyer agency agreement as long as I've practiced real estate, which is over 10 years. It's probably gone even further back since then to the 1990s. It has morphed and changed over time, but what it basically says is I have the right to represent you and your interests only. And it is my fiduciary duty to try to negotiate, advise, and give you the best information I can about prospective properties on the market. Now, it also states in there, I'm not a lawyer, attorney, a general contractor, and if at any time you seek other counsel and advice, you have the right to do so. It also states in there that I have a right to compensation for my services, just like a lawyer. When you go to a lawyer, they give you a retainer fee and then they give you their hourly rate for their services. Doctor's office, even though most of us pay through insurance, they have fees for their services. And if you're going to get something like a BBL or plastic surgery, you're probably paying out of pocket. And it's more expensive, but they gave you a list of services and what you should expect. So you should think of realtors in the same sense of any other legal practitioner that you deal with your body, your mind, and your legal matters when it comes to your finances. We're here to guide you and be your professional advisors of all things real estate. And if you get a great one like myself or someone on my team, we're going to be a trusted partner and a family member for life. So I haven't addressed what this actually means today. We talked about in the 1990s, that's when buyer agency agreements got started. And now we're here in 2024. We have a new court case where NAR got sued for $418 million. That's a lot of money. What happened? Well, there has always been what has been called cooperative compensation. Cooperative compensation is where a seller with their listing agent agrees to offer a buyer's agent, air quote selling agent, a compensation for bringing a buyer to purchase the home. It has always been the seller's right to negotiate and decide on the percentage that they offered that buyer's agent. It has never been a standard, and it was up to the listing agent to help the seller understand their market and what is advisable to offer in compensation for a buyer's agent that may bring a buyer to purchase their home. There's many different ways people negotiate this and talk about this with their clients. We do not ever want to set a standard that there's a standard percentage. It has never existed. Now, there has been a couth practice of what's expected based off of what the services are rendered. And that is common anywhere you go. You know what a Big Mac costs if you buy it here in America or if you buy it in China. The Big Mac index is set to keep pricing the same no matter where you go with the exchange rate. And you should think of real estate services in the same manner. Now, as far as the compensation, all the lawsuit really said in layman's terms is that the seller no longer can offer it in the form of a compensation. However, they can offer it to the buyer's agent in the form of a credit. So if you've ever closed on a home and you see an ALTA, which is a closing disclosure that a seller and buyer both review before closing and selling their property, you would normally see here in the Washington metro area, the selling side, the seller, paying for a buyer's compensation and a listing compensation for both of the agents. All that's going to happen now is that buyer's compensation is going to be moved over on the buyer's side. And if the seller agreed to offer credit to the buyer, you will see a debit and a credit for those two items. So let's break it down in numbers. If I'm selling a house and the agreed buyer's compensation is $10,000, the seller can offer me a $10,000 credit. And then on my buyer side of my ALTA, my closing disclosure, I will see a debit of $10,000 and a credit of $10,000. The seller gave me the credit and the debit was for my agent's commission. So all we're really talking about is moving one line item from this side of the document over to the next. In addition to that, there may be some sellers, which has always been their right, to not offer buyer's compensation. In that scenario, whatever you signed in your buyer agency agreement with your realtor would be responsible for covering those costs. I do want to note that. Again, if there is a property where Cooperative compensation is not offered in the form of a closing credit after August 17th, when the law officially goes into practice. You, the buyer, would be responsible for paying for your agent. Now, there's already states that are doing this, even down to tenants and landlords. So this is business as normal. Don't get scared. Now is the time to buy a house. So don't let this court case scare you. Real estate is the #1 wealth creation in America. It is what the American dream is about, because we're one of the only countries that allows a 30-year mortgage and has interest rates as low as they are. In some other countries, you don't even get to own the land. So buy land, buy real estate, and don't worry about this court case. There's always a class action suit correcting bad habits, and we will continue, I promise, to make our services better, provide you professional advice, and be your practitioners in this industry to ensure that everybody continues to grow wealth in real estate the way they should be. So if you have any more questions, you can always follow me down below, inbox me, DM me, or follow me on my social media handles. I'm Marlena McWilliams, the pit bull in the skirt, the principal owner of Mascotti and Company, and we are your household lucky